very much. Thank you very much also for to the Environmental Law Association for this opportunity. Hope that you can hear me properly. I will try to share my screen. Actually, here we are. Okay, can you see the screen? Fine. So I'll just go into the topic as soon as I can. This is an outline of my this afternoon presentation. As first, I will try to give you some insights from a comparative environmental and climate change law perspective. Most probably, some of you are already accustomed to such milestones in comparative environmental and climate law. And then the second part is mostly focused on the COVID-19 pandemic effects. Then I will speak about the EU Green Deal, but we will see. Actually, they seem quite three topics that they are on their own, but then I will merge them in the conclusion. And let's go to the first part of my presentation. It is about comparative environmental law. So there are a lot of really avant-garde milestones in comparative environmental law. One of these is for sure the 2008, according to my opinion, the 2008 Constitution of Ecuador, that in Article 71 states that nature or Pachamama, where life is reproduced and occurs, has the right to integral respect for its existence and for the maintenance and the regeneration of its life cycles, structure, functions, and evolutionary processes. In Article 72, the same Constitution of Ecuador states that nature has the right to be restored, and it's an obligation for the state, natural persons, or legal entities to compensate individuals and communities. Another important constitutional provision is the one that we can find inside the plurinational state of Bolivia's constitution of 2009, in Article 34, which states that any person in his own right or on behalf of a collective is authorized to take legal action in defense of environmental rights. Some remarks about these two approaches. They are top-down approaches from the Constitution, so they go from the Constitution to the legal system after civil society's pressure, after a bottom-up pressure, and this is an example of the interconnections among traditions and civil society movements and the legal system as well. And then the nature is considered as a legal subject, and there is also a wide legal discipline of the locus standi, and there is also a wide range of petitioners that are admitted to the courts. Another example of these new approaches to environmental law is the Te Awa Tupoi Whanganui River Claims Settlement Act of 2017 that declares the river as a legal person which all the rights and powers and duties and liabilities of a legal person. There are also other approaches that are mainly procedural ones. The previous one were from the perspective of constitutional law and from state law, but also really interesting aspects in comparative law related to procedural rules. One is, I think, the Atrato River case, Colombia, and the other one, the Ganga, Yamuna, and Himalayan glaciers in India, that is still sub judice before the Supreme Court of India. So the Constitutional Court of Colombia in 2016 declared the existence of serious violations due to the omissions of state and other state bodies and local bodies, an omission to provide an adequate, articulated, coordinated, and effective institutional response to face the multiple historical, sociocultural, environmental, and humanitarian problems that afflict the region and that in recent years have been aggravated by the realization of intensive activities of illegal mining. Continuing, the Constitutional Court of Colombia recognized the Atrato River, its basin and tributaries, as an entity subject to rights of protection, conservation, maintenance, and restoration by the state and ethnic communities. In India, the Uttarakhand High Court, following the reasonings from the Supreme Court of India about Hindu deities and their legal personhood stated that both the Ganges, and its main tributary, the Yamuna, as well as all their tributary streams, every natural water flowing with flow continuously or intermittently of these rivers would be legal and living entities having the status of a legal person with all corresponding rights, duties, and liabilities. Of course, these approaches carry with them several main legal issues. For instance, the ones related to guardianship in case of water management duties among different states within the federal borders, the definition then of the presence in loco parentis and the borders of the local stand itself, and then the main question is who is liable for damages caused by the rivers. And then about climate litigation. So I told you during the introduction of my presentation. So environmental milestones in comparative environmental and climate law, and this I think is one of the most important judgments related to climate litigation, because in 2019 the Supreme Court, the civil section of Netherlands, stated that in spite of a proper compliance with the EU climate regulations in sector covered by the emission trading system, then the Kyoto Protocol and the United Nations Framework Convention on Climate Change, the Dutch state acted negligently, just implementing reduction targets already imposed, without going further in the protection of Dutch citizens. So the court recognized that the state declared that the state has a positive obligation to protect the lives of citizens within its jurisdiction under the Article 2 of the European Convention on Human Rights and so on, especially when there is the necessity to face industrial activities which by their very nature are dangerous. And if the government knows that there is a real and imminent threat, the state must take precautionary measures to prevent infringement as far as possible. There are 5, I think, leading themes in this judgment. The first one is to comply with reduction targets does not suffice in facing climate change. Second one is the application of the precautionary principle in a very bold way. Then the direct national domestic implementation of the international law regime, and then the role of the IPCC and other official scientific assessments, and then the development of and the solution also, or they tried to solve climate issues within the human rights narrative. There have been other cases, of course, in 2005, 15, 19, and so on. Another point really important is currently, I think, also the role of environmental courts and tribunals. Currently, we have 1,200 ECTS in 44 countries at a national or state provincial level, and only in the United States in 10 years, there have been 13,000 litigations about environmental law, while the Grantham's Research Institute on Climate Change and the Environment counts 374 climate litigation cases. As you can see here, this one is the situation actually in Europe. So we go from the 63 cases in the United Kingdom to the one case in Estonia, Sweden, or Czech Republic, or zero case in Italy, for instance. And this is a map. So the green countries are the countries where at least there is a still pending climate case, while the orange bullets indicate the countries where there is at least one environmental court or a tribunal. As you can see, most probably, civil law legal systems are less suitable for climate and environmental litigation. Probably I'm still working, this is probably the main topic of my ongoing research. So let's shift to the second part of my presentation. It is about the COVID-19 pandemic effect. On the left side, you can see the anthropogenic emissions, anthropogenic greenhouse gases emissions in China and in Korea pre-COVID-19. And then on the right side, during the lockdown and immediately after. This one is a a picture of the India Gate in New Delhi. So I lived in New Delhi for almost 2 years, so I can state that, especially during this part of the year, this part of the city is like the left picture, while on the right side there is a picture taken during the lockdown, and you can see the differences. But there are other effects of the COVID-19 pandemic, that is the growing body of literature and scholarship about all the possible connections between the COVID-19 pandemic and environmental and the environment, and also in the legal field. And this is an example of an article that I read while I was in northern Italy during the first spread of the virus, and this was really this article made me astonished because of the content, because it explains, for instance, how atmospheric pollution can be considered a cofactor in high levels of lethality, this in northern Italy. So going further, I don't want to spoil next presentation, but I read the report, the paper, and I found it really interesting. I just want to highlight three points that, of course, they will be better explained later. One is the necessity to tie COVID-19 responses to climate objectives. The second one is post-COVID-19 recovery and green economy transition. They must be developed together. And then a third statement in this report is the COVID-19 and climate change are both systemic, so fast-tracked, and they need scientific solutions. Then I would like to focus on this paper written by Professor Rowell, COVID-19 and Environmental Law. He wrote this article while he was recovering from pneumonia, and it is about the changes triggered by the pandemic. The first one that he highlights is behavioral changes, the second one, demographic changes, and then changes in values. So this third point may serve also my presentation this afternoon, because I'm trying to lead the presentation towards a sort of demand for a think different in regarding to environmental law and climate change law. And then the fourth point is changing resources, but there is also a very bad effect related to COVID-19 pandemic, that is the environmental legislation rollbacks. Usually several states use the COVID-19 as a cover topic. One example for the others is, for instance, the attitude of the Trump administration and the Environmental Protection Agency during the first wave of the pandemic. But let's see how European Union also dealt with these two or maybe three leading issues of our time, so the environmental degradation and the anthropogenic climate change and the COVID-19 pandemic. As pointed out by the head of the European Environment Agency, he asked, it's a rhetorical question, of course, can we achieve our ambitious targets in the years to come when we will be dealing with the impacts of this major crisis? And then he replied, a socially just transition planned and implemented over a long term is the only way forward to build a resilient society with a strong and sustainable economy. So a step back, the EU Green Deal. So I think that the European Union is trying to solve the COVID-19 pandemic issues, also merging them, as also Gilda and Rumble highlighted, tying COVID-19 and climate objectives. How? Through the EU Green Deal. The EU Green Deal, the main target of the EU Green Deal, of this set of policies, is to overcome climate change and environmental degradation. And because Europe needs a new growth strategy that will transform the Union into a modern, resource-efficient and competitive economy where there are no net emissions of greenhouse gases by 2050. And how? So as first, moving to a clean, circular economy and restoring biodiversity and cutting pollution. And on the legal field, through the European climate law, to turn this political commitment into a legal obligation. And then on the economic field, with the financial support and technical assistance through the just transition mechanism. As you can see from the timeline, the month of March didn't, so the main spread of COVID-19 pandemic didn't stop the EU Commission in Parliament work. So they are going further in trying to assess the EU climate law that is still a proposal. And about the main topic of the EU Green Deal, about the policy areas, as you can see, we have clean energy, sustainable industry, or sustainable agriculture, and about the ways to ensure more sustainable, environmentally respectful production cycles. We have the main target is making the EU climate neutral by 2050, and then climate action or measures to cut pollution rapidly and efficiently. But the core of the EU Green Deal is the Just Transition Fund that will help us, first people and citizens, and then companies and sectors active in or comprising carbon-intensive industries, and then member states and regions with high dependence on fossil fuel and carbon-intensive industries. So let's go to the conclusion. So the main question is if our current political, legal, and economic approach is capable to face environmental, climate, and pandemic crisis. This is the main question. And then if we need all the legal dogmas to solve further and new issues related to the environmental degradation and anthropogenic climate change, as well as the effects of the COVID-19 pandemic. I would like to recall, according to this, just to trying to reply to this question, what Spinoza stated about the rights of nature. So according to Spinoza, the rights of nature interpretive repertoire, environmental destruction results from assumptions ingrained in legal structures and not from inadequate enforcement of environmental laws. So we need to think out of the box. So the old style, the old-fashioned economic responses or legal responses, most probably they will not suffice to solve all the issues that we are still living. And in fact, I would like to recall a statement by Jaffrey in reference to climate justice, that a business as usual scenario will entrench or further deepen inequalities and exacerbate environmental damage. So the first question could be divided in two other questions. So should we reconfigure legal structures in reference to environmental and climate law? And then should we focus on existing economic and legal paradigms to face COVID-19 pandemic, environmental degradation, and anthropogenic climate change? Of course, this is just my opinion. I think that it's really crucial to reduce the gap between ethical, economic, and legal or technical understandings of environmental climate issues, temporarily linking them with the COVID-19 pandemic ones. How? So all the aforementioned assumptions demand for a transformative approach. As first, reducing the gap between the ethical debate and the legal one. Then finding a place for justice in its ethical and distributive meaning inside the concept of litigation, then opening legal systems to face the challenges of new legal subjectivities, making procedural laws elastic enough to encompass radical transformations, and then tracing back the borders of a new locus standi, and then I think the most important one, that is changing anthropomorphic features of law to serve a more holistic and heuristic approach. Thank you.